Welcome to our webinar on a lawyer's guide to strategic thinking for businesses during the pandemic. I'm Doug Foreman. I'm with Fringe Benefit Plans. And Tina Kraft and I would like to thank you for attending today. Fringe Benefit Plans, we've been in business since 1969, and our mission is to serve our clients with enthusiasm, innovation, experience, and expertise. That's why we partner with CPAs and bankers, attorneys, other professionals to help our clients bring value to you. Our vision for our company is to protect our community from the hardships of life's unforeseen events, and that's where we assist in putting in benefit programs as well as HR needs and concerns. And it's been trying times for us, as well as I know everybody on this call. It's very, very strange times. We just want you to know that we are here for you, and if you have any concerns regarding any of the items we talk about today, how to handle new hires, if you have them coming on, if you have how to handle terminations, how to handle the First Family Act, First Family Act, we're here to help you. Some expectation for today's call. We will be ending at 3 p.m. We have set this up for screen share only, and I'll be introducing Nate McCoy here in just a moment. There is no video. We did that on purpose to help reduce distractions during the webinar. Everybody is on mute except for Nate and myself. And we will be taking questions though. And for those of you have your screen up and you see the legal update experience, if you look at the very bottom or use your mouse at the bottom, for most of you, you'll see it where it says chat. We have set this up where you are able to send a question through the chat, and we will be monitoring those questions. And time allowing, we will be asking Nate some of those questions right here on this call. And if we are not able to answer your question, we do ask that you can email myself, Tina Kraft, or Nathan directly with those questions, and we will respond back to you as best that we can. So use the chat feature to submit your questions. We'll be responding and answering as many questions as we can. We are also recording this webinar, and for everybody who has registered, we will be sending a copy of the recording to you, as well as a copy of this PowerPoint, so you have this information as well. You should expect that in the next 24 hours. And again, if we don't answer your questions during this meeting, please feel free to send us an email directly. With that, Nathan, I'm going to hand it over to you, and if you could share a little bit about yourself as well, and then get started on the webinar.
Thanks, Doug. I appreciate that. Hello, everyone. Thanks for tuning in. And as Doug mentioned, I'm Nathan McCoy. Just to let you know, I'm an employment attorney here in Orlando. We also practice business law. We are really thankful for the opportunity to speak with everyone, especially with regard to all of the changes that have occurred, including those as recent as of Friday. But I do want to thank Tina and Doug, for their partnership here. They've been fantastic resources. I'm sure you all have received emails from Tina, over the last week or two. They're fantastic resources in terms of what's happening out there, in terms of, everything really affecting, businesses with respect to coronavirus, et cetera. So I do appreciate them, and I hope you all do too. But a little bit more about myself. I'm an attorney at Wilson McCoy, PA. As I mentioned, we practice employment and business law. I've been practicing, now for 17 years. Time flies, but no better time to practice than right now. It's a chance for us to be of service to each of you, and hopefully be able to help you, through this crisis right now. It's really impacting everybody. And I'm not going to go over everything of what is coronavirus. At this point, everyone knows. It's serious. It's having an impact on all businesses, not just in the state of Florida, but across the nation. And because of it, it's presenting challenges to everybody. from office closures, newly created family responsibilities, remote work arrangements, and near hourly changes to local and federal laws. COVID-19 has brought a new difficult reality for us all. And sometimes when I do these type of presentations, I try to think of, oh, geez, maybe we should make some of these things lighthearted. And I don't disagree with that. Like I said, this has impacted us all, depending on the type of business you have. But one thing I thought originally this was going to be a video chat. And so, with changes, we have clients that are, salons, et cetera. So I thought, oh, well, maybe I'll get a haircut. Well, you can't, right? That's one minor impact right now, to some of us, but major to some of our clients. I thought about having my daughters cut my hair, but I thought, oh, no, probably not a good idea. That might be a little embarrassing. You never know how that's going to turn out. But coronavirus obviously is impacting us all. And so, within the last 30 days, this has been unprecedented change. We've all been told to do basic things like wash our hands, avoid travel, leave work if you're sick, work from home, self-quarantine, keep your social distance, and close non-essential businesses. These are all things that are strange to us all, and we're all trying to, to comprehend and see what we can do and still maintain our normal businesses. But we're in an environment right now where that's just not the case. The things that have changed the most, and especially within the last 2 weeks, of course, are the new laws. The new laws that have been passed, which are impacting small to mid-sized businesses. The first, which many of you have probably had some level of adjustment to, is the Families First Coronavirus Response Act. That passed, I think, March 18th, which seems like such a long time ago at this point in time, given the most recent change, and that's the Coronavirus Aid, Relief, and Economic Security Act. The CARES Act is what it's really known as. For small to mid-sized businesses, the question is, what do they mean to us? How are they impacting us and how we operate? Well, the reality is that they're severely impacting us. And at first, with the Family First Coronavirus Response Act, the FFCRA, that change itself looked pretty. It was a hard one for small business to swallow. It would have created havoc for most of them. But luckily, the CARES Act has passed, and that's going to potentially provide some relief to small businesses. And we'll go through that in a minute on how those things or how those changes are helpful to businesses and how we can actually use the changes as a strategy for moving on with our business and how we can continue to keep our doors open. The other thing, though, is, of course, it impacts the other laws that are out there and existing. And so it creates additional questions for employers, both small and mid-sized employers, of how do we continue to operate in our prior legal environment with the new changes. And so we can talk about some of those, of course, during the question and answer as well, because I know each of you probably have questions. So first, just talking about the Families First Coronavirus Response Act, again, you've probably been accustomed to that at this point in time, but that doesn't mean you still don't have questions. There are multiple parts to it, but one of the first things is the Emergency Family and Medical Leave Expansion Act. And what that does is it creates a unique situation, an additional leave for people who are impacted by coronavirus. And this leave is extended, or it applies really to any and all employers with 500 employees or less. Notably, though, businesses with fewer than 50 employees may be exempt from all of these requirements if they can prove that providing the leave would risk them from going out of business. Now, that's really something that I think most of you, or may apply to many of your businesses, and it's something that the Department of Labor is supposed to be giving us additional guidance on. We don't have, regulations. We just have FAQs at this point, so they're guidelines, but they're not exactly reliable at this point. But there is hope for some of our businesses that we can actually help and get exemptions from that. And so we're, of course, staying in tune on that, and we're going to help businesses with that if that's something that's concerning to them. But in general, with this FFCRA, until the end of the year, employers with fewer than 500 employees will have to give leave up to 10 weeks of paid FMLA. Now, that's, of course, a contrast to typical FMLA, which is unpaid leave. The first 2 weeks of leave are actually going to be unpaid, but after that, there's the 10 weeks paid period. And the issue here is that I think that many employers are missing at this point in time. A lot of our businesses or business clients have actually gone remote. If your employees can go remote, this act or the leave portion of the act is not going to apply if they are at home working and able to provide care to children who are at home or their schools are closed because of coronavirus. So that in itself, is something that I think a lot of businesses need to know, and from a strategic standpoint, need to be aware of. Just because an employee has kids at home, if they're working remote, that means the leave may not apply to them. Another thing to think about with the FFCRA is the Emergency Paid Sick Leave Act. This is unique, and it's really an impact to everyone here in terms of, again, what coronavirus has done. It's created sort of mandatory sick leave, which many of our employers and small businesses and mid-sized businesses didn't even offer to employees before, paid sick leave. But if you're impacted, or if your employees are impacted by the coronavirus under these certain conditions here that are listed in the presentation, you will have to provide them with leave. And of course, they can receive a certain amount of pay. There are daily max and complete maxes or caps on how much they can actually receive during this time period. But this alone, as I mentioned before, could have been disastrous to some of these smaller businesses. And we'll go over this some more during the question and answer session, but something else to note is, again, there are exceptions here, and that there's the 50 employee companies can actually move for an exemption. And we're hoping to be able to help some businesses with that along the way once there's more guidance. The other major act, of course, which is impacting small businesses, and this one just completely passed on Friday, is the CARES Act. It's a huge influx for businesses in terms of the amount of money that's coming for aid if they need it. It actually applies, to small businesses as well as self-employed and independent contractors who kind of run their own businesses. There's a lot of information contained in the actual act itself. The bill itself was 880 pages. I've read nearly every word, and there's a lot that does not apply to businesses, but devil's in the details. So, not that I'm suggesting each of you actually read that. It's not something you need to do, but there are certain provisions that you do need to be aware of. Among those are the Paycheck Protection Program, a portion about loan forgiveness, emergency grants for small businesses, and enhancements to unemployment benefits in covered individuals. We'll talk about each of those here just for a moment, and then of course get back into the idea of having the question and answer session. But the interesting portion about the Paycheck Protection Program, which I find to be a fantastic opportunity for clients at this point in time, is that you can actually receive a loan from the federal government, which one is backed by the federal government, which you can get 2.5 times the average monthly payroll that you've had over the last year. And that loan is interesting because it can be used to cover a number of things, including payroll costs related to the continuation of health plans, employee salaries, commissions, or other compensation, payment of interest on mortgage obligations, rent, utilities, interest on any other debt obligations incurred before the covered period. So you could actually use this loan for a lot of things. All you have to do is certify that you're using this money in good faith for some of the reasons that I just mentioned. What's great about this, though, is that there's the possibility for there to be loan forgiveness. And this is a huge benefit to small to mid-sized employers right now, especially when you don't know what's going on with the rest of your business, whether you can operate, whether some of the local ordinances will allow you to have your people in. So having this available to you and possibly be forgiven is a huge advantage to small employers right now. So you can actually have it forgiven, have the loan that you've taken out forgiven, if in the event that you actually keep your people employed. In other words, It doesn't have to be the exact same amount of hours in particular, but your payroll needs to be pretty close. You can take a reduction up to 25% at most in order to still remain eligible for this loan forgiveness. If you've laid off people previously, you can actually bring them back, to help out with the balancing of numbers. But this is absolutely a fantastic tool to be able to use as a small, mid-sized business when you're combating the effects of coronavirus. So it's something that you should be aware of. And just so you know, that loan applications are just now, I think, starting to be available. You can actually go through some lenders right now to pre-qualify, and there's really not much you have to have. You just needed to be in business since February of 2020 and actually to qualify for a loan. There are, certain limits on how much you can qualify for, but nonetheless, it is actually, a fantastic option for most small to mid-sized businesses. Something else which is kind of interesting and unique here is that there are other loans available in terms of the CARES Act. Some of those are just the SBA sponsors, the emergency loans, emergency economic injury disaster loans, EIDLs is what they're called. You can borrow, previously it was $350,000 was the max, but now you can borrow up to $1 million at low interest rates. You can actually, if you are requiring less than $200,000, you can actually not have to personally guarantee that if you are a business owner. So that, of course, is great incentive for a lot of businesses who are trying to keep their doors open. Another thing that's created here is the opportunity to receive a grant. And this grant is up to $10,000 and usually can be obtained within 3 days after applying for the grant. Now, that amount itself is, may not satisfy long-term issues for a lot of businesses, but for some of you who have, you don't have a lot of people on your payroll, or have a lot of otherwise other expenses, that's a fantastic option, and it is a grant as opposed to traditional loans. It is worth noting that you can actually both borrow, in addition to borrow under one of the EIDLs, and still apply for the paycheck loan as well. So you can do both. However, the loans cannot be used for the same purpose. Realistically, what purposes those are that would be different, I can't really tell you at this point in time, but it is something that is available. And if you take out one, it's not necessarily going to prevent you from using or taking out the other. Something else for employers to be aware of course, with the CARES Act is that the changes to unemployment. The reason why this is important is because there's a lot of questions out there already as to whether or not there's almost an incentive for employees not to work, for either to be laid off or terminated or even quit. But something you should know is that it extends unemployment insurance by 13 weeks and provides a 4-month enhancement of benefits. So what we mean by that is if someone actually has applied for or qualified for state benefits, state of Florida is $275 per week, they can actually get an additional $600 payment on top of that based, from the federal government, based upon the CARES Act. To qualify for benefits, you can see the list here. It's pretty exhaustive. It's got to be a direct impact or a direct result of COVID-19 or the coronavirus. And that's what it's in essence for. However, there is an interesting provision at the end, which I've highlighted and put in red, and that is that if an individual quits their job, they can still qualify. You should note in the past, traditionally, people would not be available or be eligible for benefits if they've quit. It has to be a reason attributable to the employer for that to occur. So this change is huge in terms of what that potentially means. And for some individuals out there who work in difficult environments, for those that are still open, for instance, such as grocery stores, things of the like, where you may be exposed, to the coronavirus more than others who are staying at home, that's something that, could be a consideration for them. So that's there. Employees who are at this point in time working home or remotely, or receiving paid sick leave or paid family medical leave, they're not eligible for the unemployment benefits. So that's something worth noting there. The working remotely, again, is a huge impact. If people can work and they're working from home, they're not traditionally going to qualify for really any of the benefits under either of the acts that we've discussed. You can see here, again, the additional dollars that are available. It's $600 per week, even above what was already being provided to people for unemployment. So again, the question then is providing this type of benefit incentive for employees to no longer work. And we're going to analyze that a little bit more here shortly. Each of these new laws, of course, is creating additional legal questions. And this is just showing some of those questions and what those might be. I'm sure that each of your businesses, they're all unique. You all have your own, but it's something that you have to analyze because each new law impacts other laws. And it does create these additional questions such as, do employees have incentive to quit? Do I have to follow CDC guidance relating to COVID-19? Can I take an employee's temperature? All things which you probably couldn't do in the past, but they are permissible at this point in time. So I'm happy to answer any of these type of questions that you have, after this presentation. The point of this presentation, though, is not to go over the details of each and every one of those laws that have passed. Those things are available everywhere. They're certainly confusing. You could read FAQs everywhere. You can read summaries. But what we want to do is start analyzing from a strategic perspective of how do they really impact each of your businesses, because that's ultimately what we're looking at here. And as a small business, how can we take advantage of these things, or how can we avoid closing our doors because of the new obligations? The first thing I have under strategic assessment is, can your employees work remotely? Again, if they can, there is a chance that none of the new laws, in terms of, for instance, the new FMLA law, the extension there, the paid sick leave, the new unemployment compensation benefits, those will not apply if your people can work remotely. So you want to do that as an analysis. Is your business capable of working remotely? That's not going to apply in every case, but it's certainly going to apply in some. So if you need assistance with figuring out how you can become a remote workforce, there are options available. You can certainly talk to people like us for guidance, but you can also look to those SBA loans that are out there, because some of that money can be used to help build the structure that you need to create a remote workforce. You can avoid a lot of payments for other things when that happens, or avoid a lot of other disruption to your business. The next thing I have is, how long can your business stay open with or without SBA loans? We briefly touched upon the different types, and there are many options available. Again, whether you need a larger loan or a smaller loan, what you need to do, of course, is start looking at your own finances. How long can you stay open? What kind of what kind of revenues are actually coming in? Your accounts receivable. What can you do for forecasting out of how long can we survive? How long do we expect payments to come in if we're not open, or if we can't reach our clients directly, or if your doors are closed, you can work remotely, but you had more sales when you were able to work or meet clients face to face. All of those things need to be analyzed before determining which type of loan that you're actually going to get. The other thing is if you get one, is there any difference to, or is it going to prohibit you from getting another type of loan? As I mentioned with the paycheck portion, in which you can borrow 2.5 times your payroll, for a loan, it won't prohibit you from getting other types of loans. But just so you know, the $10,000 grant that you can get under the SBA as well is going to be used as an offset to lowering that amount. So the entire amount would not necessarily be forgiven. So you might have to take away that $10,000, in that scenario. But those are all things you need to start doing and start analyzing to figure out, how much you're going to need, if any at all. Another thing to do is to look at your organization and figure out if you could benefit from a restructure. Not all restructures are the same. We'll get into this here in a minute too, in terms of the different types of restructures that can be done, whether you're doing a furlough, a layoff, reduction in force, altering schedules, even changing your business hours, from a traditional, 9 to 5, but maybe it makes sense for your workforce to keep your doors open longer, but rotate employees to make sure that you're keeping the quote unquote social distancing options available, or that you're following those guidelines. That's what I also mean here by, can my business operate differently? Are there things that we can do, or what kind of adjustments can be made so that way we're complying with the laws, but still being able to run our business? Another question is, can I partner with my customers or clients to retain business? That's something that, we all need to start looking at and figuring out what can we do to help each other and make sure that business continues, because the last thing you want to do is shut off all business just because some are having more difficulties than others. We'll touch on that here in a minute as well. And where do you get assistance from? Well, one of the first places, and we've already, of course, thank Doug and Tina and Fringe Benefits Plans, great resource already. They're a great partner to have. If you have your employee benefits questions, they're available. They're already sending out information after information regarding changes into the law and changes to the business environment as a whole. People like us, attorneys, are invaluable right now simply because we can help give you the proper guidance to keep your doors open, avoid lawsuits in the future. So you've got to look to your partners. Your accountants are also going to be helpful because there are tax credits available for any or most of these acts that have been passed. And you have to determine whether you qualify for any of those credits. So strategically, we have to start looking at these things, to make sure that our doors, or all options are explored so our doors stay open. With respect to restructuring, as I mentioned, there are options. If you aren't sure what a furlough here is, I've kind of defined it, but the whole idea is that it's an alternative to just a straight layoff. When you have a furlough, you're basically reducing the hours, that someone is actually working. But still allowing them to work. So for example, if you have an employee who traditionally works 40 hours in a work week, a cost savings benefit to you may be to cut their hours back from 40 and have them work 32 hours. Or maybe they work 4 days a week instead of 5. This adds up, of course, in terms of for you, especially if you add that type of furlough plan to all of your employees in terms of cost savings. Now, of course, caveats are there too in terms of your type of employee that you have. You can't reduce certain pay for certain exempt workers for doing any work at all. So but there are things that you can use a furlough for, and that's a great tool to have. An alternative is a layoff. Now, a layoff is a temporary separation from payroll. An employee is laid off because there's not enough work for him or her to do, and that may be the case for a lot of our businesses and clients right now. Just because of the overall impact to the global economy. They may not have what they previously did. So you might have to temporarily lay off people. The idea here is that they can collect, of course, unemployment while they're laid off, and then the idea is to bring them back when business picks back up. We don't know at this point when that will be, but it's certainly an option. Another thing to do is a reduction in force, or to consider. And that's, of course, when positions are being eliminated. If you're evaluating your business and you determine that you have 10 positions and certain positions where, this is just for example, but 10 positions available and maybe only 8 are really necessary or 7 are necessary, you can cut back those which are unnecessary at the time and eliminate that to cut down on costs. We can all evaluate our businesses at this point in time to determine, what's feasible and what's not, and what's, the right structure. We can all trim some fat. It's not that we want to do it, but sometimes for the benefit of the business and the longevity of the business, you have to do things like that. So this is the time now is to consider, the structure of your business and figure out what you can actually do to help survive for the long term. Something else that we put in here is when we talk about partnering with clients, and this is a concept that I've kind of come up with, and it's Go Red for businesses. And what I mean by that, the acronym of RED, is reduce, extend, and defer. We're all in business. We're all here. We're all trying to help each other at this point in time through the difficult times. If you have clients that are having a hard time paying, it's better to reduce the amount that's actually owed to you, extend terms, defer payments whatsoever. than have nothing at all. And in fact, I like to, use this saying, I think it's that an empty seat never bought a hot dog. Of course, that's more of a sports reference, but it's the same thing. It's the same idea when you're actually looking at the current business environment. If you're stopping business with someone altogether just because they can't pay, well, in the long run, that's bringing you, of course, no revenue. The better option may be to reduce payments or pricing. Like I said, extend your terms or defer payments altogether. And one thing to do for each of you is that if you're going to do this, always want to get that in writing. You may even want to come up with an agreement. It's something that we actually have put together is a go-red agreement. So that way you can extend terms and defer payments or reduce payments or pricing altogether. The idea here is that it's for a limited basis. It's not for the entire term. Sometimes you can actually, just extend at the end, your regular terms, but you're giving your clients the ability to do something now. At the end of here, we're going to talk, I'm going to be available for any type of questions that you have, which are impacting your business directly, but we want you to know that our firm is actually here for you too. We've done and we've followed through on our Go Red plan itself, but we've created what's called a critical needs advice plan. A lot of you have questions, during this crazy time. We have answers, but we want to make sure that our advice is available to you at deeply discounted prices. And in fact, if you go visit our website at wilsonmccoylaw.com/COVID-19, you can actually see those plans and what they are. But we're here for you because we want to make sure that we're helping you keep your doors open, keeping your people employed. That's important to us as being good stewards of our community. So we want to make sure that you're aware of that. And it's not just us. There are other counsel available out there. But you do need to get the advice. Don't just rely upon FAQs to get the answers that you need. So that's just a general overview of some of the things that are going on. And I just wanted to get you all thinking strategically of what you can actually do at this point, and rely upon counsel to help you get through those things and make sure that we're not violating any laws by making changes. So Doug, if you want to open it up to questions, I'm happy to answer them.
Thank you very much, Nate. And we have been getting some questions coming in through the chat button. Again, at the bottom of your screen, or if you're on an iPad, it might be in another location, you can submit questions via the chat. And I do have some questions to share with you right now. If you are ready, okay. Nate. So the question is there an exception to the pay, FMLA, or sick leave for temporary staffing companies? Temporary staffing companies, do they have any type of an exception to this FMLA and sick leave?
Typically, there's not. I mean, they're going to be required to actually, cover it as well, because if most temporary staffing are, the actual employer of some of these individuals. So that is something that is not, in terms of overall guidance, been discussed fully. So unless and until that's actually discussed by the Department of Labor, the answer would be yes. They have to cover it.
Okay. Gotcha. If we reduce hours, can the employee still file unemployment for lost wages? So they're still employed, but a reduction in hours. Can they file for unemployment?
Okay, great question. And so what that is called is underemployed. And so, yes, people who are underemployed, so if you make a reduction, to your overall hours, that can actually be a great tool for both the employer and the employee, during this time. It's almost an issue of sharing, the burden here of what's happening. And what I mean by that is that because of the changes to unemployment, they're going to qualify for their own state-based unemployments simply because of being underemployed, but they can also get the benefit of the additional $600 as well. So the point is that an employer can still get the benefit of someone using less hours. They're having to pay a little bit less from their own payroll, to cover it, but the employee can get a benefit as well. So that can actually be a great combination available to both the employer and employee during these tough times.
Okay. So this is a question on a similar line. They say they have mostly exempt employees that work for them, To avoid layoffs, the employees have agreed that they will take cut in hours. With them being exempt, can I do that, or should I cut their pay by, say, 20%, 1 day a week, based on a 5-day work week?
Sure, that's also a great question. So anytime you're looking at cutting pay or reducing hours, you got to make sure that you're not violating any potential exemptions there. And so right now, if you're looking at the pay portion, to qualify for any of the exemptions for an exempt employee, it's going to have to be, $35,000, almost $36,000 at this point. So if you cut, you got to make sure that you don't cut below that. But in terms of overall hours themselves, of course, if an employee is exempt, it's not going to matter how many hours they actually work, whether they work 10 or they work, 100. The pay that they receive is intended to cover all hours worked. So for that perspective, you just got to look at the amount of money that you're cutting back. But otherwise, so long as you're not falling below that level, you can make those cuts. The alternative is to give up the exemption and convert them, at least temporarily, to non-exempt workers, and then of course cap the hours that they're actually working. So that would be the alternative. So you'd be giving up the exemption under that scenario. But it's certainly something that can be available that you can actually do to save money. And again, it's not that anyone wants to do, but it is certainly an option available.
Okay. A lot of the questions are revolving around this April 1st date, which is when the Family First Act starts for the extension of FMLA. And basic questions that are coming in is should we encourage our employees to take leave, or should we just go ahead and terminate those employees before April 1st? And there's a lot of chatter about that. A lot of employers are saying, "Gosh, maybe we should just terminate if we're going to terminate them here in the next expectation in the next week or two. Let's terminate some now prior to the April 1st date." What's your advice on that?
Yeah, I think the first thing is to do that strategic analysis. How many employees do they actually have? Remember, there's the idea of if there are 50 or less, they can provide, there's an exemption to that. So the issue of falling under the Family First Coronavirus Response Act, it may not be applicable to their businesses if they have, less than 50 employees. So that's the first thing. But after that, yes, you should always do an analysis in terms of, okay, what's going to be best for my business, based upon the circumstance. And I would, implore any employer to actually look and figure out from a number standpoint, is this something that would make most sense for my business at this point in time versus using, the SBA loans or that, to borrow for payroll, the 2.5 months for payroll. You've got to look at it from every perspective. So, is there a right answer to, that question for every business? Probably not. But it's certainly part of the strategy is to evaluate that. People will, of course, even if you have to eliminate, employees, there is the ability for the employee to actually, fall under the new unemployment categories because of coronavirus. So the money will be available to them. So, if you have to make that hard choice, don't feel too badly because money is available for bailouts for the individuals afterwards. But if you can keep them employed, remember, you can actually receive a benefit too in terms of free money of that loan forgiveness if you're keeping them employed. But you just have to determine, does this apply? What is the long-term effect here? Am I going to need people? What's the long-term effect? If they're a good employee, are they going to come back to me if I let them go? You've got to do a very, very thorough analysis before making that decision.
Okay. With regards to the Family First sick pay and FMLA, you have a 2-parent family, and are both parents allowed to take leave simultaneously for the child care reason? Or can an employer request a letter from the other parent's employer stating they are not taking leave and or are not working? So 2-parent family, can they both take leave? How does that work?
I'm not aware of a regulation which would actually prevent that at this point in time. Now, it would be different if it was the same employer. Again, regulations have not been issued on this. If it's a different employer, No, I think that the employers would have to extend the benefits to them. If it's the same employer, that might be a different question in terms of the ultimate burden. But again, is it a company in which they would even have an exemption? So I assume they have 50 or more. Is that correct?
I don't know the answer to that question.
Okay.
Yeah, I'm not sure. Okay, so you got that one? You're good with that one?
Yeah, I mean, again, I think because of the regulations have not been fully issued on this, in terms of competing employers, in essence, if they, if you have two parents that need to be out, or can they be out at the same time? The issue though is that, again, if it was one employer, I think they would be able to prevent that. So only one of them would be able to leave. But if it's two different employers, I'm not aware of a provision yet which would prevent it.
Okay. If an employee catches the COVID-19 on the job, but then they are furloughed, do we have to pay them for the 2 weeks, even if the company doesn't have the money to do so?
I missed the first part, Doug. Could you say that again?
An employee catches catches the disease, but then they are furloughed. Do we have to pay them for the 2 weeks, even if the company does not have the money to do so?
Right. So, again, if you're looking at the situation and they would have otherwise qualified for the sick leave, yes, it needs to be paid. If they're ultimately furloughed, they're still going to get paid, but the employer needs to actually make amends for that. They can actually recoup some of the payments back. There are tax credits available to the employers who are making those type of payments. So the system does account for that.
Okay. All right. So question looks like it must have come from a school. School campuses were closed on March 17th. Sick leaves takes effect April 1st. The update from the Department of Labor seems to indicate that employers who closed their worksite prior to April 1st, even if this closure was due to government order, they do not qualify for the FFCRA.
That's correct. Yeah, that is correct.
Okay, so that they're just wanting to confirm that. So
there are no retroactive benefits under the FFCRA, but again, that's what, if you go to the new act, the CARES Act, there's going to be some available relief there for individuals. If it's a question from an individual, or if it's even from the employer there, from the school, there are some other options there where people who have been laid off can get some relief.
Okay. So switch gears over to the CARE Act. Question is, if we participate in the PPP loan, and after the 8-week period our business has not picked up, are we able to begin layoffs without any repercussions to the loan forgiveness?
So I think the question is asking if after the initial time period where they would otherwise met the obligations of the PPP loan, the question is, can they then thereafter make reductions? And the answer to that so far, again, without regulations, is yes. There's nothing, tying back, in terms of like a clawback. If immediately after you've had the loan forgiven, will you be subject to a clawback or having to pay back if immediately thereafter you make changes? So again, that's a great strategical question from whoever asked it, because those are the things you need to look at. Those are opportunities to take advantage of the laws that have passed, but you also have to, of course, as a business, look forward to it. There's free money available, and hopefully, things will, the ship will be righted and business will return to normal. But if they don't, you still have to make strategic decisions, and that may be one of them.
Okay. Question came in from a nonprofit. Are you aware of any grants or loans for nonprofits that have under 20 employees?
So under the CARES Act, nonprofits actually qualify too. So I believe that there will be some relief available to them there. That grant, it depends on how much money they need, but there's the grant that's available. immediately for after 3 days. So that's the $10,000 option. But other loans are also available based upon this CARES program. So where they may not have otherwise qualified.
What is the max money a business can ask under the EDIL to not have a personal guarantee? That might be.
The max is up to $200,000. Anything above that, there can be a personal guarantee. So, again, that's strategic question as well, because, I'm a business owner myself. I would certainly feel, of course, a lot better if I didn't have to guarantee it. And the thing with a lot of SBA loans, you never know, if there are going to be additional, extensions to the loans that are provided by the government, or, other type of forbearance. There are a lot of things that are great about SBA loans, but this is a fantastic thing about the one under the CARES Act right now, is that, you can actually get up to, it increases up to $1 million, I believe, but you don't have to guarantee anything up to $200,000.
Okay. All right, so now we're switching back over to some more family first questions. If an employee gets 2/3 of pay from the employer and has been furloughed, can the employee file for unemployment to make the difference up in their hourly wages? I think you answered that one earlier.
Yeah, so what happens is that if they're qualifying under one of the other acts, either the sick leave or the paid leave, they won't get the payment from the state, that's for sure, during that period of time. But once that has been paid, then they will. Again, you're going to get the $600 stimulus there for unemployment compensation from the federal government. But you have to, it doesn't apply at that time, but it will thereafter once that's over with. So for instance, if they're under leave, but then they can't come back to a job or they're laid off, then they'll qualify for the other benefits.
Okay. If an employee has been home taking care of a child at home from school for the past 2 weeks, is the employer required to start paying them the FMLA 2/3 beginning April 1st?
If they've already been home, is that the question is?
Yes.
Okay. The first question is, are they able to work remotely? That's the threshold question. Assuming that they cannot and they're at home with their child, then they would actually qualify effective April 1st.
Okay. All right. Another one for the CARES Act. Will the loan with possible forgiveness apply to businesses that use an employee leasing or PEO company for their payroll and insurance?
I've not seen anything which would indicate otherwise. So, you may use that service, but that service may be covered as part of, one of the benefits that you can actually use because it is the, payroll. So I haven't seen anything which would suggest otherwise.
Okay. If an RIF is done prior to applying for the PPP loan, does that impact the eligibility for loan forgiveness?
No, not if there are a couple of things in there that, especially if you rehire any of the people back, that would be one of the issues that you would basically need to do to qualify, for that. So you can bring some of those people back. The idea behind the CARES Act and that PPP provision is that you want to keep people employed, or you want to actually bring them back to work. So that gives you the incentive to obtain the $3 or the loan forgiveness at the end of it. So you'll want to bring them back in order to qualify.
Okay. If an employer requests an employee to stay home for 2 weeks after they've traveled from another country, or might even be from New York City these days, does that employer have to pay the employee paid sick leave?
If they have forced them to be out, and it's not necessarily under an order, but they're establishing some of those symptoms, the answer would be yes. That's the safest play here.
Okay. How do employers count their 50 employees if they have furloughed employees? Do those still count?
If they're furloughed and they're still Well, again, furloughed it depends on the definition you're using here. So if you mean that you've already laid them off versus furloughed, meaning you just cut back hours, that's a different question. But assuming they're meaning laid off, meaning they're no longer as part of the employer, as part of the workforce, that number is going to be established based upon your prior averages. That's what it's going to be used. So that's going to be evaluated, again, in terms of, whether you're qualifying for one of these things or whether the loan will actually be forgiven in the future. So there is a difference, though, in that question between furlough and laid off.
Okay. So can you expand on that? Because they asked about furloughed or laid off. Who do you still count?
Okay, so again, looking at the situation, if you're talking about, this is for the PPP, is that correct?
Count for 50 employees if they have furloughed employees. I'm not sure. I believe it's the Family First Act because it's referencing the 50 employees.
Okay, so again, if you're talking about 50 employees and we're only looking at the Family First Act at this point in time, and you've reduced down, so maybe you were at 55 employees, but prior to the act is effective date of April 1st, if you've cut that down, well, that's not going to apply to you, any further. So then you have to look at the actual date of the effective date.
All right, here's a good one. So somebody has to close their business for at least the next month. They have an employee who's on a non-compete and is now working for a competitor. Since my business is closed, I'm not sure when I can reopen, but I know I will eventually. What can I do regarding that non-compete?
Oh, that's a great question. And so looking at that, it's a really, really good question. So just so you know, in the state of Florida, there are cases out there in which judges have said that, look, if you're closed shop, then we're not going to honor, the non-competes any further. This is unique because we now have laws that are being passed, which are allowing people to come back, if you will, or these loans to breathe life back into some of these businesses. And so I would argue, even though there's certainly nothing on the books at this point, with these new laws, I would argue that you could actually breathe life back into those non-compete provisions as well. Especially if you've taken out one of these loans and you open your doors again.
Okay. All right. Can you please define keeping them employed with quotes around it? Can they be on payroll and employed but not actually working?
It's a great question. And so that actually is something it's already up for debate. So for instance, let's say that I brought up a salon earlier. All right, say you're a salon and you right now, because of the social distancing, you can't bring people in, or a lot of people aren't going into that type of business right now. The question is, for those salons that have employees and they're not actually serving clients or working, does that count as being employed? Well, if they're on your payroll, the answer is yes. So are there things they could do? Could they, review policies? Could they, clean a shop? Could they do things like that? Of course they can, and that would still be employed, under the circumstance. So those are the things that have yet to be defined by regulation out there, for clarity for businesses. But unless and until they are, if it doesn't matter really what they're doing, if they're on payroll and doing something, then they're employed.
Okay. Does the FMLA have to be consecutive days?
No, there are intermittent options even under the new FMLA. So just like there was previously, for intermittent options, there are here as well. So it's going to depend on the situation, but it is available.
Are there any measures for the employer that can prevent abuse of the FMLA or paid sick leave by the employee?
I think I probably need to know more or less of what that abuse might be. But understand this, that there are some measures in terms of being able or being required to produce documentation of the absolute need for leave. So that's something that they can get from doctors at this point in time, to back up the reason why they're out. But I probably need to know a little bit more about that particular situation to be able to answer it best.
Okay. So we'll have to get more information on that one. If an employer has a layoff after April 1st, do they have to pay the 80 hours of sick pay?
In terms of a layoff afterwards, I mean, again, that's going to drop them down. You can't retaliate for somebody for taking it. So if you were making that business decision regardless, right? So let's say you have, a couple of people that got impacted and they were out. If your sole decision to, fall below, a certain number of employees was to avoid making those type of payments, then it could arguably be deemed retaliatory. But the reality is that because of the situation and how it's affecting the business, it's probably going to be a solid independent decision, and one in which it would be a non-retaliatory decision. And so this probably wouldn't apply any further.
Okay. There was somebody made a comment here that said tax credits, we won't see those until next year.
Yeah, I understand that. And that's a frustrating portion, about some of these acts is that some are tax credits. But I would suggest that you get in contact with your accountant on some of those, because there might be more immediate relief under certain circumstances.
Well, and for the sick pay, the credit comes as they are doing their payroll tax, so that's a more immediate.
Yes, there is immediate relief for the payroll portion. That's correct.
So if you're paying your payroll tax per pay period, you get a credit right then.
Right, that's correct.
Okay. All right. Let's see what else we have here. Getting some great questions. They're coming in fast and furious. You've been answering so quick. I haven't been able to keep up with the next one. Here's one. We laid off 2 new hires. Each worked under 30 days 2 weeks ago, anticipating a cut. Will this disqualify us from the loan forgiveness?
No, it should not, because of what they've done is basically worked under the guidelines of the prior acts. So no, I don't think that's going to disqualify them.
Okay. All right, here's one. We are applying for the CARE Act PPP. Employment needs to stay above 10%. Question number one, what if employee quits to take advantage of new unemployment law? Question mark.
Right. The question is that going to impact the ability to get the forgiveness portion? And again, we have really no guidelines yet on that point, or any regulations, but it is something that employers have to be aware of. And so they might have to find some additional incentives to keep people there. I know it's hard, especially in the state of Florida here, if you start doing, math to figure out what that benefit may be. But what I think is you might have to do a combination of things if you want to reduce hours to some degree and still qualify. That's something you may need to do, because it provides some level of incentive for both the employer and employee with that. But you've got to keep an eye on it and make sure that people don't quit. You want to make sure that they are there to work. So you've got to make it worth their time as well. But every employer is going to have to do analysis to figure out what that might be for employees and them as a business as well, to see what they can afford to do. But again, there's no regulation or real guidance on that point if you have people resigning.
Just to follow up on that one is, does furlough impact our PPP forgiveness?
It can. Again, if you start looking at payroll numbers and you look at the ultimate amount there. So I think it was a 25% reduction is what the actual law is actually stating. So you can't fall below that. So you need to analyze, in terms of a furlough, what kind of reduction to payroll you're making. You just want to make sure you keep it above that 25% mark. Okay.
Let's do one more question here, and then we'll wrap this up. We see the maximum for the EDIL is 200,000. What is the maximum for the EIDC?
For the EIDC, I'm sorry, I guess I'm missing the point on that one. Are we talking about the credit or the actual loan itself?
Yeah, let's do it again because I'm not familiar with that second acronym. That might be a typo. All right, let's skip that one. Okay. All right, one last one here. What obligations do employers have for employees that exhaust the 80 hours of paid sick leave? Do they qualify for paid family leave at that point?
Yeah, so the question, so if somebody is qualifying for paid sick leave under the Act, the question being, did they qualify for additional leave?
Yeah, so if they've exhausted the 8 hours of paid sick leave, do they qualify for the paid family leave at that point?
They potentially can. It just depends on the circumstance. I mean, the assumption is if they themselves have been forced out of the business, or for the time being because of especially since their own issue, then chances are they're going to qualify for the FMLA portion as well.
Yeah, and I think that only applies to if they're home with a sick child, where they can get the extended.
Right. Mm-hmm.
Okay. All right. Well, Nate, thank you very, very much. It's 3 o'clock. Thank you for those who have participated and listened in and these wonderful questions. We will look through some of these questions. If it's something that we're able to reply to, we'll include that in the email that we send back. And if we did miss your question, please feel free to email Tina or myself direct. And Nate, thank you so much also for that wonderful offer of basically having you on retainer is what it sounds like, for lack of a better word.
Yeah. Thank you, Doug. I mean, it is available again for people that need questions. They just want to be able to pick up the phone and call us at any point in time. We're basically having unlimited questions for any client that needs assistance. We'll find answers. We know that this is difficult for people to weed through, but we want to make sure that we're available and a resource to clients at this time.
So in the email we send out, there'll be more information. We'll include information on that offering. And anybody who's interested, they can reach out to Nate and Wilson McCoy directly.
All right. Thank you, Doug. Thank you, everyone.
All right. Thank you, Nate. Thank you, everybody. Have a great day.